In December of 2019, a new coronavirus was discovered in Wuhan, China. In the weeks and months to follow, it spread around the globe, bringing with it illness and triggering dramatic government responses. Now, with global business disrupted, we'll take a look at if and when the coronavirus may trigger a provision known as force majeure or act of God. Hello and welcome to Talks on Law. I'm Joel Cohen, and we are joined remotely by Jose Maran, a partner at Baker McKenzie, where he leads that firm's energy, infrastructure, and mining practice group. Jose, welcome. And before we get started on the coronavirus, maybe you can lay some foundation. What is a force majeure provision?
The term force majeure, also referred to as an act of God, addresses scenario when performing contract obligations becomes impossible, difficult, or onerous to perform due to exceptional events outside of either party's control.
With that background, how do you apply the analysis of COVID-19 or the government shutdowns to force majeure provision?
Generally, there are two approaches for contracts governed by common law. The first approach is to have an open or non-exhaustive list of events where clauses include a list of example events. Force majeure events that we have seen expressly listed may apply to COVID-19, such as an epidemic or pandemic, a government action or intervention, a quarantine, a shortage of labor or materials. If there's one takeaway from the recent events, particularly in light of the very narrow construction that courts have applied in certain jurisdictions, is to add pandemic and/or epidemic language to future force majeure clauses.
Now, sometimes these lists are open-ended and leave open the possibility of events unforeseen by the drafters. How are courts interpreting that?
Parties must be very careful placing too much reliance on a catch-all language and sort of an open list. For example, New York courts and New York law construes force majeure provisions very narrowly, and a New York court typically will find an event to be covered by a catch-all only if it's of the same nature and kind and as those events that are specifically listed.
You mentioned there are two types of force majeure provisions. We talked about one. What's the second approach?
The second approach is to have a general objective test. For example, an event beyond control of the parties, an event that could not reasonably have been provided against or that could not reasonably have been avoided, or an event that is not attributable to either party.
Now, regardless of the type of force majeure provision or the drafting, are there duties or obligations of a party even where the force majeure provision may be triggered?
The affected party cannot generally just sit on its hands. There's often an obligation on the affected party to mitigate the effects of a force majeure event. For example, sourcing alternative supply or labor, even if that is more expensive, or moving personnel to avoid restrictions perhaps between two operating projects, plants, or assets. At the very least, there's an obligation to mitigate, and it will require talking to the other party to the agreement and trying to make alternative arrangements and perhaps creating an amendment to the agreement, or what is so-called a reopener.
A follow-up question, Jose. Sometimes these force majeure provisions have exceptions or carve-outs. What are you seeing in the market?
There's almost always a list of exclusions. An obligation to pay money is perhaps the most frequently seen, but matters such as economic hardship, reductions in demand, and shortages of labor are commonly seen, particularly in projects in developed countries. These exclusions can be extremely important as they can completely negate otherwise valid claims, and for existing projects, they are not always negotiated as fully and as carefully as they should.
And lastly, before we let you go, if the force majeure provision is triggered, what are some of the remedies that the parties may have?
Generally, an excuse against non-performance to the extent that the force majeure event affects performance. The affected party has no liability for non-performance, often an express right of suspension, and lastly, termination of the contract for prolonged force majeure periods.
Thank you, Jose Maran, for your time. And for those that are watching, remember, this is a global issue. So each individual case will depend on the circumstances of that case, the law governing in that state or country, and the specific drafting of the governing contract. I'm Joel Cohen. Thanks for watching Talks on Law.